Okay, great.
We're good to go. Yep.
All right, thanks, Sue. Well, welcome everyone. Thanks for joining us today. I'm Carrie Sonmore with the Battered Women's Justice Project. And before we get started, I'm going to briefly go over some logistics for today's webinar. If you are disconnected from the webinar at any time, just go back to that original email and click on the join link again, and it should log you back in. If you have any problems rejoining, if that happens, you can call iLink support, and you can reach them at 1-800-799-4510. And I just typed that into the chat box for everyone as well. You can find this chat box on the lower left-hand corner of your screen. To use this feature, put your cursor in the white rectangle all the way at the bottom, left-click, enter your text, and then hit the Enter key on your keyboard to submit your text. All participants will be muted throughout the entire webinar, so please use this chat feature for any questions, problems, or comments that you may have. If you do run into any technical problems during the webinar, please send me a private chat, and I'll help you figure that out. And again, my name is Carrie Sonmore. And how you do that is just click on that private tab that's inside the chat box, and then double-click on my name, and then a private message will open up for you to send me a message. Let's see. Why don't we have everybody try out the public chat? If you could just let us know where you're joining us from today, or if you have more than one person listening with you, let us know how many folks are with you. That would be great. So let us know anything so you can get the hang of the public chat. And then for any folks that are only on the audio portion today, you can still join in with any questions. Just go ahead and send me an email, and I'll make sure to get those over to the presenter. My email address is ksonmore@bwjp.org. We are recording this webinar today, and you'll be able to access this on the Clearinghouse website in about 7 to 10 days. Also, shortly after the webinar, we'll send out an email that will have a confirmation of your attendance. We'll have a link to where the posted recordings are online, and it will have a short survey on there too, and we greatly appreciate any feedback that you could give us. It's very helpful. And then anybody who's on the phone, unfortunately that email will not automatically go out to you. So if you could just send us a request for that, we'll get a copy of that as well. And I think that's all I have for today, so I'll send it over to you, Sue.
Thanks so much, Carrie. Good afternoon, everyone, and welcome. I'm Sue Ostap with the National Clearinghouse for the Defense of Battered Women in Philadelphia, and I really want to welcome everyone today to this webinar. And this one is the third in our series of webinars about expert witnesses. And I know some of you have been on some of our past ones, but if you missed either or both of the first two webinars in this series, recordings of the webinars are actually available on our website at ncdbw.org. And when you start the recording, it also brings up the PowerPoint. So you'll be able to get access to the PowerPoint there as well and watch it as it goes along with the recording. There is another webinar in the series already scheduled. In the next one, or the one that's scheduled, is on the prosecutor's use of experts. And that will be presented by Chris Malios, who some of you probably know. He's from Equitas, which is the Prosecutor's Resource Center on Violence Against Women. And that webinar will be held on June 20th from 3 o'clock to 4:30 Eastern Time. And it's really important to pay attention to what time zone the times are in. We're working really hard to get the announcements about future webinars up on our website, so please check into our website. You just go to resources, and that will bring you to the information about the webinars. And also, we're really trying to get them out to people via email as well. So please keep watching your emails as well. Before we start the webinar, I just want to thank the Office on Violence Against Women for the support of this project on expert witnesses, and I really want to thank dear Carrie Sonmore and other colleagues at the Battered Women's Justice Project for really their amazing and continued and truly excellent help and support with our webinars. They've really been great, so thanks, Carrie. Today's webinar is titled Considerations for Aspiring Experts at Community-Based Domestic Violence Programs. And our presenters today are Lori Shipper and Kirsten Faisal from the Iowa Coalition Against Domestic Violence. And I have to say that we at the National Clearinghouse have really felt extraordinarily lucky to have the Iowa Coalition represented by these two truly amazing women be project partners with our Expert Witness project. And we asked them to join the project because, over the years I've become aware of how very thoughtful they are about their own expert witness work, especially as advocates in state domestic violence coalitions. And I think they've done a really excellent amount of good thinking about the role of community-based advocates being experts, which is certainly a big part of the reason we asked them to present today. They're really very smart and thoughtful and also amazingly caring, and so it's just been a real joy to work with them, and it's really, truly my pleasure to introduce both of them today. Lori Shipper is the Executive Director of the Iowa Coalition Against Domestic Violence, and she's been working with the Better Women's Movement for over 30 years. Lori has tons of direct service experience that I think has really informed her work at the coalition and as an expert. And she's assisted literally thousands of Better Women and the children over the years. And before coming to the coalition, she worked in a Better Women's Shelter and Rape Crisis Center in Ames, Iowa for over 10 years. Lori is really an amazing teacher and mentor, and she provides technical assistance and conducts numerous training programs for advocates and other professionals. And she also has been working on developing training programs and curriculum for a long time, and she does a lot of public policy as it relates to violence against women. She also has extensive experience in her spare time testifying as an expert witness and or participating as a trial consultant. And she's done this in literally over hundreds of cases involving domestic violence and the impact on children. She's developed training programs for new and for experienced experts. She's conducted statewide training programs for experts and legal practitioners. And as I mentioned, she's been a real instrumental part of our Expert Witness project as well. And I really would like to just take a second to add a personal note. I just, over the years, have learned so very much from Lori, and it's just been really great to have kind of a more formal way to connect with her through this project. She's really a very wonderful and special woman, and someone who I truly believe is one of the giants in the Better Women's advocacy world. And I have really grown to appreciate her wisdom and her amazing leadership. And so it's really my honor to get to work with her. And it's such a pleasure to introduce her today. So thanks, Lori, for all you do. Kirsten Faisal is the Director of Training and Technical Assistance for the Iowa Coalition Against Domestic Violence, and she's been in that position since 1995. She works at the coalition on developing public policy. She provides professional support to agencies that impact Better Women and their children as well. She, too, comes to the coalition after providing direct service, and she spent 11 years doing crisis intervention work with survivors of abuse. And I think that for both of them, this direct service has really made a big difference in how they testify and what they talk about in their testimony. Kirsten wears many hats at the coalition, and she's on the steering committee for the Batterers Education Program for the Iowa Department of Correction. She's trained for the Iowa Law Enforcement Academy and the Department of Human Services. She's also served as the chair for the Iowa Domestic Abuse Death Review Team. She, too, has provided expert testimony in many civil and criminal domestic abuse cases. And like Lori, she's been incredibly helpful in expanding our thinking here at the National Clearinghouse about advocates as experts. So before handing this over to my two colleagues in Iowa, I just want to say to those of you who may have just joined us that I'm Sue Osthoff with the National Clearinghouse for the Defense of Better Women, and Carrie Sonmore, the Better Women's Justice Project in Minneapolis, is also on the phone, and we too are hosting today's webinar. And before we have Lori and Kirsten start their actual presentation, we have 4 short questions that we would really appreciate those of you who have signed in to iLink to answer, if you would answer them. And I do appreciate your patience because this information is actually incredibly helpful to us. Carrie, do you want to put them up? Would you mind doing that?
Yes,
I'm sorry?
I'm trying to do that right now, but for some reason it's not working for me.
Okay, let me see if I can put these up. Huh. Well, maybe we're just going to move on because they don't seem to be working for me either. Sorry about the technical glitch, folks. Let's just see. We're going to try one more time. If they don't come up this time, we will just move on. I have multiple copies, and none of them seem to be working. There must be something going on. Sorry about the technical glitch, folks. So we'll just then instead hand it over to Lori, Shipper, and Kirsten Faisal from the Iowa Coalition. And I did want to just point out one thing. Because they're on the same phone, that's why Lori's photo is not up. They signed in as Kirsten, and so we're not seeing Lori's lovely face. So sorry about that.
Thanks, Sue. This is Lori. And thanks, Carrie, too, for both of you hosting. I wanted to start out by saying what a great opportunity this has been for us to work with the Clearinghouse and to get to share our experiences with the Clearinghouse and with you all this afternoon. For me personally, this has been extremely fulfilling work, and so I always get excited when I can share it with others. So I hope that you're able to get what you want from the webinar today. Kirsten and I are also going to be handing the phone back and forth to each other, so hopefully that won't be a distraction to you, and please let us know if you can't hear us at any point. We're going to be talking about our experiences as expert witnesses and that evolution. Others, in fact even others on this webinar series, will have differing experiences, and you may have had different experiences as well, and I think that's okay. It's really added to the richness of our dialogue anyway in planning these webinars, and I think we've all learned a great deal. When we, as experts, and I would tell you that Kirsten and I do the majority of expert testimony on domestic violence in our state, and when we can't, we felt the need to train and mentor and then to create a referral list to advocates that we believe are qualified and skilled and we have observed being effective in that role. And at the same time, we also felt the need to educate the bar about who and what they need in an expert to make sure that we weren't doing harm by starting to do this work. And so I would really encourage you to think about ways you can build that kind of accountability to survivors into this work as you move forward. As well as we're going to be challenging you a lot through this workshop to examine your own motives and your own skill level very carefully as you move forward. Again, so that we are all doing this for reasons that benefit survivors and the work that we do and help our communities. So I'm going to pass it over to Kirsten and let her introduce herself, and she's going to start.
Hello, this is Kirsten, and yes, on everything that Lori just said, both in the thank you for having us and also in that I think that this particular, as we were talking about what we were going to say, we thought we're probably going to end up leaving people with more questions than they started with, and I think that's fine. For myself, I was working in a domestic abuse program probably 17 or 18 years ago now, and I had an attorney contact me regarding a custody case, saying they wanted somebody to please come in and talk to the judge and explain why giving custody of children to a batterer was a bad idea. And my first reaction was, well, duh. But my second reaction was, duh doesn't constitute expert testimony. So what on earth am I going to do, and what am I going to say, and can I even do this, and how does it happen? And the first person I contacted was Lori, who at the time was probably the only person I could have contacted anyway. I don't know that there was anybody else in Iowa really doing this work. So, so partly this is about talking. These are lessons from my own experience and also lessons from Lori's experience, who has kind of led the way through what has been blank territory for us up to this point. We are going to be very much focused on advocates working in local community programs. I think people who are interested in doing expert testimony from allied professions will probably find a lot of this helpful, but their mileage may vary somewhat. Some of their concerns will be the same. They'll probably have some different concerns. So this first question of are you an advocate, or are you an expert? I really think that you'll actually take a while to figure this out. It is still, expert testimony is the one thing that scares me the most still in my job. I'm perfectly happy standing in front of hundreds of law enforcement officers or social workers or anybody else and talking about these issues. This seems to be different somehow. It takes a lot more planning and a lot more different kind of thought for each case. I do also think of it very much as essentially training. It's just that you're either talking to an audience of one person, a judge, or perhaps an audience of 12, a jury. So as we begin this, we're just going to start at the ground level and talk about you as an advocate sitting in your domestic abuse program. What is your background? What is your training? It varies somewhat state to state what they will allow as an expert. Iowa has pretty loose definitions of who is an expert and who is not. So having formal education is a great thing. If you don't, it doesn't necessarily bar you from being able to fulfill this role. If you have the knowledge and the experience, they would compensate for that. If you have, so what is your formal education? What are your certifications that you may have? Are there professional trainings or professional certifications of any kind that you have acquired or that you can acquire? And if you've got those things, begin to pull them together so that you can take a look at what can I talk about? What is my experience? What do I have to show for my professional experience? You need to be somewhat conversant or very conversant with current research and issues in the field, which is a very difficult thing, I believe, for somebody who is day-to-day in the trenches of advocacy. It's simply because of a lack of time. You're going from one crisis to the next very often, and sitting back during your 5-minute lunch in the car of Mountain Dew and Snickers reading a journal article is probably not your thing at that moment. But you do need to be able to think about and discuss what those issues, and particularly the controversies, are. You don't have to have an answer, but I'm thinking questions like, is the Batterers Education program effective? What are the controversies that surround that? The whole issue of gender equity and domestic abuse. What are the various narratives around that? What are the arguments? And what are your responses to those arguments? Another issue that I think we need to be aware of is the whole issue of cultural humility. And I mean a couple things by that. I mean that a lot of what we supposedly know for sure, or what the research is on both survivors and batterers, is based on white folks, white folks who are in the systems, who are in, what we know about battered women is about white battered women in shelters. What we know about batterers is very much about batterers who have been arrested and convicted of domestic abuse. That's not all of what we know, but it is a substantial portion. And to just be aware that that does not necessarily reflect the experience of a lot of other communities. So there's that whole issue of how far can I speak with authority, and where are the unknowns, particularly in regard to different communities. I also think there's so there, am I the best person to talk about this? Or is there somebody who would be more qualified from a culturally specific program that, with some mentoring, would be a really good expert to do this particular case, or to pull into this work? Because we could also use more experts from those specific communities to do this particular type of work. The flip side of that, which I have once in a while encountered myself, is kind of the trap of representing a community. I can think of recently in the last year having several conversations with a prosecutor about the whole issue of Arab culture and honesty within Arab cultures, and victims telling the truth or not, and was that a victim thing or was that an Arab thing? And you may have gathered from my name that yes, I do have a connection there to Saudi Arabia, to be specific. And so while I could say some things, I had to be very cautious that I wasn't representing all Arabs in general, certainly. And quite frankly, I knew nothing about this particular survivor's experience or why she might not be cooperating, what she might be saying, or why.
Kirsten, I'm sorry,
Yes.
This is Sue O. I'm sorry to interrupt. Some people are saying they're having a hard time hearing you. So if you can speak up a little bit, that could be helpful.
I will shout. Yes.
Thank you very much. Lori was actually easier to hear, so not sure.
Interesting.
Okay.
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 So then think about what your experience has been. What has been your professional role? What have been the things that you've been doing within your job? Number of clients and counseling hours, and by that I really do mean sitting down and doing a best guesstimate. It's one thing to say, yeah, I've worked with survivors. It's another thing to say, I have worked with approximately 100 or approximately 1,000 over the course of X number of years. And what would that mean in terms of actual counseling hours? Are you an expert? Are you the person that your peers call when the local law enforcement agency needs somebody to come in, when the substance abuse agency is looking for some kind of speaker or even consultation? Are you the person that they get a hold of? So how do the peers in your community regard you? Are you asked to do trainings? Are you asked to write articles for your paper or for local newsletters? Who do they go to? Do you have any affiliations? Are you part of, are you a member of the National Association of Social Workers? Are you part of the National Coalition Against Domestic Violence? What could you add that are things that keep you keyed into your professional community? And then there's personal issues about whether or not you would be appropriate for this work. There may be, and some of these may come down to case-specific issues, and some of them are more universal. We'll be talking a lot about the issue of hats, and the whole issue of privilege and confidentiality gets right to the hat issue. Am I somebody's advocate, or am I a fact witness, or am I an expert witness? And you have to be absolutely clear about those three roles. So hopefully there is no confidentiality issue with this particular case. So the question is, do you have any other relationship with this client? Have you ever been an advocate? Is there a chance that you would be an advocate for this person in the future? Or for clients that might be affected by you testifying about this case in the future? If you have any other hats that you might wear, if you also are a social worker, how does that hat affect your doing expert testimony as an expert in domestic abuse? Personal bias is a little bit more slippery for you to try and get a grasp of, but I think that's part of the self-examination. Why am I doing this? Am I excited about doing this? Does it seem fun? If so, just take a step back. It may not be so fun. And that leads pretty easily to the next issue, which is stuff about yourself that might come up on the stand, and how comfortable are you with dealing with that. And I have been asked if I'm married. I've been asked if I'm divorced. I've been asked if I have children, the gender of those children. I've been asked if I have been assaulted in the past or a victim of domestic abuse. I haven't been asked very often, but I have been asked. And it's much more likely that you'd be asked in deposition than on the stand. But still, it is possible that you will be asked those questions. So how comfortable are you answering them? Do you have answers ready for those kinds of things. Have you testified in some other case in the past where that would impact your credibility speaking this time? Do you have a judge in the past who said, no, I'm not going to allow this person as an expert? That one's big. You already have a record of a judge saying that you're not an expert. Have you had any other case where issues around your credibility as a witness have come up? And I think the last thing I'm going to talk about before handing this over to Lori is about your personal teaching style. As I said, this to me is really a training opportunity, just on a smaller scale than we often do. But you will have to rally all of those training resources that you would have otherwise, those public speaking skills, and apply them to expert witness testimony. I know that there's going to be more about this particular issue and prepping and honing your teaching style. So I'm not going to go into too deep stuff, but just things to think about along the way. Can you present in a very clear and concise manner? Can you make your words visual, make them clear? Can you use exhibits effectively? I could draw the power and control wheel in my sleep. Can you take things that are very complex and make them so that the average person and or the judge can understand them? Another thing is just the way you present. What is your stage presence like? And is it a theater? Well, it's not, but in ways it is. So what is your presence like on the stand, in the courtroom? Can you seem both passionate about what you're talking about and at the same time unbiased? You don't want to come off as having an agenda. You want to come off as being neutral, but you also want to be engaging with the jury, engaging with the judge, so that they want to listen to you. And so that's about the words you're using, your voice regulation, your presence, your appearance, all of those things. I even have what I call my going to court pearls. So it's the only time I wear them. It's a nice, very conservative strand. Those are my going to court pearls. And just putting them on, it helps me to assume this unbiased, neutral, authoritative persona that I want to present. And I'll pass it over.
Okay. I just want to add a couple things following up what Kirsten said. I know that we're making this sound hard, and that is actually by design, because it's not for everyone. Not everyone that wants to do this should do it. And being a wonderful, extraordinary advocate doesn't necessarily mean that you'll be a wonderful, extraordinary expert. So that's why we want you to think really critically about it and evaluate whether this is for you. I had the luxury of my first case, which was a murder case, of a year to prepare. And I will tell you, it took every bit of that year for me to get ready and to do the reading that I had not had time to do as an advocate who didn't have a lot of control over my schedule during the day because of crisis intervention activities. So time to do that is really important and will help you feel confident. But I always like to tell my first bad story during this murder trial. I was working with a state public defender who actually taught me everything I know today. And he had me in a deposition, and I had read the entire summer everything that was ever written about domestic violence. And because I crammed it, of course, I'd had it memorized. So I memorized every author and what they wrote. And when I was asked in deposition about what I was basing my opinion on or my authority on, I listed them all as fast as I could. I couldn't tell you if they were a man or woman necessarily or how to spell their name. And I could see him just sink down in his chair, the public defender. And later he told me, you do know that everything you say in a deposition you're responsible for. And do you know what any of these authors said on page 32 of their book? And I was terrified until trial. So that didn't come back to bite me, but it was a very good learning opportunity for me. Okay, so will you be supported? This is crucial. I know today that I would not still be doing this work had I not had support both in my agency prior to the coalition and at the coalition level. It requires far too much emotional investment as well as time commitment. And it can be a burden for your coworkers because you are traveling, you are gone for extended periods of time. It does certainly not a revenue source. I want to make sure that people know that. Although we would definitely encourage you, urge you to get paid for your time, please know that you will not make money for yourself or for your agency doing this work. At least we have not. And if you charge too much, they simply won't use you as an advocate. They will use someone else in the community who may or may not be more qualified. So some of the administrative things to think about is there's a billing process. You have to keep very close track of your contact hours with the attorney in order to be able to bill at the end. And so who will be doing that billing part of the work for you? Will your agency support your travel, your lodging? If you're testifying outside of your catchment area, you may have to stay overnight. If you're the last witness on a day, they easily go over and you have to come back in the morning. Not all clients can pay, so in most civil cases, it's our experience that adding expert witness fees onto what she's already incapable of ever paying off is an added hardship we're not willing to do. So even though we definitely do have fees, they're negotiable, and each staff member is allowed to negotiate those fees at will. Okay. We want you to think about the impact that this will have on your agency, and you can't do this in isolation. You have to discuss this with your other staff members. How will it impact your clients? And these are things you really have to think about in terms of unintended consequences, perception of your clients, and your community. And then I think something we don't think enough about is the impact it has on you personally. I have worked with, as Sue said, lots and lots of women, survivors over my lifetime, but I will tell you that the ones that still haunt me today are the cases where I was an expert and it didn't go well. And I will tell you that without that kind of thinking about the impact on myself personally and the work that I do is really crucial. And I would say Kirsten and I probably evaluate that from time to time, sort of on a regular basis. And there have been times when both of us have said, I need a break, or I need a break from this kind of case. I can't do family law. Listening to that mother scream when they gave custody to the batterer was more than I can do for a while. And so to set boundaries as well. And I would also suggest try to negotiate that with your agency. Once your agency decides this is in their mission and they want you to do this, make sure that you have the flexibility and the autonomy to be able to put some parameters and set some boundaries for yourself. In terms of the personal, sometimes it feels like you're the only voice and you are all that's standing between her or him and prison, or as I said, losing her or his children. And so it really does take an emotional toll, and you need to think through whether this is something you want to do. It's a lot of pressure, and you do need a personal support plan. Other policy considerations. Is expert witness work compatible with your agency's mission? You need to have a talk about this. It may be even something that you want to discuss with your board and come to a conclusion whether or not you think this makes sense for your agency to do based on the work that you do related to your mission. I also want to say something about policy. A lot of times in this field, we create policy, or our policy evolves because of a bad experience, and we have a knee-jerk reaction to it, and we make a change. I want to caution you from doing that on a case-by-case basis, and instead have ongoing dialogue about why you do what you do, why you decide what you decide. and do that with people that you trust within your agency, or if you have mentors outside of your agency, talk through all of this. Does your agency have the capacity to devote staff time to expert testimony? If your program is in flux or even in crisis, if you're short-staffed, this may be unmanageable or too much of a burden for your coworkers, and is, as I said earlier, is certainly not a program revenue source. And so you would want to factor that in before you start. You also may want to consider doing some type of needs assessment in your community or your state to see if there's actually a need for advocates as experts. Are there other qualified or more qualified folks covering the need already in your state? I haven't actually heard of a state where that's true, but you may have that locally. And then you can put your time and effort into other activities. You cannot be, as Kirsten said, both the advocate and the expert in the case. These are very different roles, and you have a different relationship with the victim. And if you gray those roles, and I would say nearly every expert has, you will at some point hurt a victim. She expects you to act like an advocate if you're going to be an advocate, and there are things that come with that: confidentiality, valuing her right to self-determination, and having your role support that self-determination. The expert role is very different. It is about educating the court so they can more effectively and more justly do their job. You work as part of excuse me, the legal team. I'm committed to this because I have so many examples of survivors who may not have felt it was safe to cooperate or felt like it was a strategy to recant. And after sitting through expert testimony, have come up to me afterwards, almost always in tears, feeling and expressing gratitude and astonishment that someone was able to put voice to their experience. And that's always made me second guess whether or not I should or shouldn't testify, because I have so many of those survivors who have approached me, and it felt like there's a place for this type of role in this process, within the system, in terms of seeking justice and fairness. Are you planning to testify as an individual? So that would be at your own expense and your own liability, risk, or as a staff member. I would tell you that I can't imagine doing this as an individual. I have relied heavily on the safety net of my agency and my coworkers. And I would have you really think through what that would mean to you in terms of isolation and what other supports you might have in place if you were thinking about doing this as an individual, from what I know about advocates' lives in general, in terms of other supports you might have available. What is your procedure for accepting or rejecting a case, and who decides that? This is probably the most difficult thing that you will encounter doing this work. It is not easy, and in some ways it feels arbitrary at times. And some of the things that Kirsten and I will tell you we have in place, you'll probably think that we are heartless and that we are being arbitrary. But what I would want you to know is that on any given day, we could have 3 to 5 calls come into our office for expert testimony. We can't take that many cases. It would be unethical for us. We couldn't prepare. We couldn't do justice. We would hurt our individual and agency credibility if we tried. So we have to have a way to screen cases and decide what types of cases we can take. And so we've developed our own procedure for that. Your agency may have other capacity, other factors you want to consider, and just so you think through that and know why you're doing what you're doing as you evaluate that. We testify in all types of cases: criminal cases in both state and federal court, civil, administrative law cases, immigration, torts. But with all of the cases, we do require, with rare exceptions, one instance of physical violence coupled with other power and control factors. So both those things need to be present. We require that the attorney is willing to be educated if they're not, and that they're willing to send us material from the case file for us to review. And for attorneys I've worked with routinely, I would say, send me whatever's relevant, and they'll do that. For an attorney I haven't worked with previously, or I've had a not necessarily a positive experience with, I would require that they send the entire case file. We require a timely request for our services. You have to give us enough time, and if this is your first time, I would really, 6 weeks is a very fast pace to review a file, make your own estimation of whether or not you can be helpful. It would be much better if for your first case you had several months. As I said earlier, my first case I had a year. I think that helped build a foundation for me that I still use today. So Kirsten and I, if they call, Kirsten just had a case where they called her the day before and tried to convince her that this was a punt case, she could show up. And we have done that. We've all made that mistake where we have decided, I can do this. It's so compelling, especially when advocate calls, because you all know you can be very compelling. We've made the mistake of going ahead and doing it. I would tell you I can't think of a time where it worked out well, ever. Without reviewing the case for myself, I think that's a big risk for her. We require a determination that a domestic violence expert is necessary for the case. It's not just because the attorney really wants us, really thinks that they've heard great things about us and they want to weight the case and really go for the big win. There really needs to be a reason to use us in the case. For one, it's a resource issue. We just simply don't have time to be that extra bit of weight in their case. There needs to be a reason. So is it a good defense? Is the theory good? Or are we just extra baggage, which actually usually ends up making the court frustrated and angry and hurts her or stereotypes her in cases where she simply doesn't need that extra education of the court. Can her story stand on its own? And can she effectively tell it? We see this a lot in battered women defense cases where it is a very clear case of self-defense. She can articulate exactly what she did and why, and we believe that the average juror can understand that. Would it be necessary for us to come in and label her, just by our presence, as being battered, which we all know carries a whole list of other stereotypes that the community and jurors certainly have? And it could actually be detrimental when her case stands on its own and she can tell it. In our office, it's often a staff decision whether we say yes or no. I usually always consult with Kirsten or another staff member or multiple staff members. First, to make sure that I'm articulating any biases that I have that might impact my decision to take the case or not. We discuss the ethics, both on an individual case level and the ethics of what we would be saying about a particular group of people or a particular kind of case, and again, what it would mean to our agency. And then I would say, and I don't know if this is okay or not, but I will tell you it's true. The bottom line is my last question is always, can I live with my decision? And because I've made mistakes, that is a very important question for me. I can think of 2 cases that will haunt me forever, that follow me and factor into all of my thought process about expert testimony, where I believe I made the wrong call. And I don't know whether or not there would have been a different outcome, but I know how important that question is for me to answer. Fees, we set fees. We have a policy, and as I said earlier, those are negotiable, and each staff member is given the autonomy to negotiate that at will with the attorney. I would tell you that everyone that we've ever talked to says our fees are ridiculously low. We have not changed our fees because so often, again, they're passed on to the survivor, and we know that it's additional hardship. But even more importantly, when the system, the county, or the state are paying for those fees, our fear is that if the fees are too high, we simply won't be used or no expert will be used, which is often the case with many women who are incarcerated today. It was just too much of a bother. It was too expensive, and she got no assistance in that way. So we want to keep our fees not a factor in the case, but we definitely want our expenses to be balanced, and our time paid for if possible. I would also suggest that you have a mechanism to get supervision and think through what those supervision requirements are. Kirsten and I provide each other a lot of supervision, but we also have mentors outside of the agency that we also use as sounding boards that we get a great deal of supervision from as well. The subpoena, again, if you're separating your role, at the coalition level, this isn't as big of an issue because we don't fall under the counselor privilege law of our state. So when we get a subpoena, it's almost always something that we need in order to get reimbursed by the county attorney's office. So we gladly accept that subpoena. When I get a subpoena and I have had no contact with the attorney whatsoever, have never reviewed the case, which happens, I simply make a phone call and educate the attorney about how ill-advised it is to subpoena someone without any knowledge of what they're going to say on the stand, and that it's really bad practice, especially to treat an expert witness in that manner. Now, if you're a domestic violence program and you act as an advocate and you're testifying for women that could possibly be using your services because they're in your catchment area or have used your services, then the subpoena is a problem. Because then when you show up at court as an expert and take the stand, it is in all likelihood that someone is going to exploit the other information you know about that particular survivor. And she, because you're on the stand, has for all practical purposes waived her privilege. And so what you go in thinking you're going to do a domestic violence 101, you end up having to talk about her parenting skills and other information that she would never have wanted disclosed. And I will tell you that as much as you think you know, you couldn't hurt her on the stand. If you don't have those roles separated, they will exploit that and you will end up hurting her on the stand. Or you'll be given information about her you didn't know existed, and coupled with what you know, you'll hurt her. So be very, very careful about that. Oh, sorry, I went too fast. There we go. Will you take cases if one of the parties receives services from your agency? I hope you've heard us cover this by now, but just to make sure, I think it's really important that you don't do this, that you separate that role and you only take cases outside your catchment area. It keeps your advocate role with the people using your services cleaner. It keeps her perception intact of what your role is going to be. So what we have encouraged our advocates in Iowa to do is have a relationship with local advocates in another area of the state and sort of have a reciprocal relationship where you will act as a referral for their area and they will as yours. And the other perk to that is that almost all of our communities see someone coming in from outside as more of an expert than the local shop is. So that's also helpful. In terms of expert witness records, we keep them, each staff member keeps their own files, and we treat them like client files. And I keep mine forever. Not everyone else does. The reason that I do that is because after 20 years, I have found that it is not unusual at all for me to get a case, recognize the name, go to my files, and realize that I testified against his father 15 years ago. And those kinds of conflicts and relationships are really important to be able to know. You should definitely keep your expert witness file separate from your client files. Okay. How will other system agents view your expert testimony? This is system change work. You do it every day. You educate people in your community about why you work with certain populations of people. For instance, if your agency works with incarcerated survivors, think about how you initially explained that to your community, your funders, the prosecutor. Especially, I think, people within the criminal justice system understand these different roles. For instance, a prosecutor and defense attorney go to lunch. They consider themselves friends. They understand it's their job and their role. They do their job so the system works toward justice, which is, I believe, how you can easily explain your role in this way. We call it the red, white, and blue. People within the system understand that you have, you're innocent until proven guilty, and that the system only works when everyone does their job. Not my first murder trial. Yes, actually it wasn't the first murder trial I referred to earlier. Following my testimony, of which I was terrified, we haven't talked about that. Kirsten mentioned that earlier, that this is scary sometimes. And I was young and I was very, very frightened. But following that testimony, the prosecutor in the case called me immediately following and said that she was impressed and wanted me for an upcoming trial. There was no hard feelings whatsoever. In fact, I think that our agency received a great deal of respect because it actually did fit in with our mission and showed integrity in terms of what we believe about what survivors have a right to, regardless of what other things and complicating issues there are in their lives. Women with lots of multiple barriers who bring other things like criminal records, child abuse to the table still have a right to have violence-free life. And if you believe that on a level that you're willing to support that in your community and educate your community about why you do what you do, I think you actually get credibility and people see you having integrity. So what kinds of cases will you take? This is also very difficult because once you sort of get a reputation for doing good work, you'll have folks call you that may have ulterior motives sometimes. So you'll have to consider what your policy is on taking cases involving male victims, how you feel about battered women who kill. And actually, my favorite story that Sue Osthoff doesn't remember is when I was a young green advocate, I went to her telling her, actually trying to brag a little bit so she'd be impressed with me about my first murder trial. And she looked at me with this sort of tired advocate head shake and asked if I'd ever been alone in a room with someone who'd murdered someone. And I will tell you, I had not. And I hadn't thought about what that would feel like. That was a really important question early on in my work for me, to examine what I believe and who I will and can help. So you might hate the behavior of a particular survivor. For instance, if she's charged with child endangerment and she did or was present while terrible things happened to her children. Can you separate those feelings, or do they override your belief that people should be able to live violence-free? And if you can testify in that. If you can't, you should walk away. The other thing Kirsten and I always do when we first talk to an attorney is we ask them to tell us what they don't want us to know about their case. Tell us what are the problems with your case. And these are the things that attorneys are afraid you won't take the case if they tell you that, you know, she's recanted 3 times previously or lied on the stand or turned her kids out to work in prostitution. And those are the things that actually, for us, mean you indeed need an expert in this case, that we want to be available to women who've been marginalized and may otherwise not have an equal playing field in the court system. And our belief system is that they deserve it. And without knowing those problems, we can't appropriately address them with our expert testimony. So that's our first question to attorneys. It makes them very nervous, but then they get excited that they have a partner in trying to solve some of those problems. I would end that with just in terms of perception in your community. If your program's at a place where perception is your main concern, you may likely have work to do before beginning this kind of work in the first place. So if that's a very serious concern, you might want to evaluate whether or not this should be an area that you're starting to go into until you've found a different place in your community for your program. Okay, I'm going to turn it back over to Kirsten.
Okay, so I'm going to take some of this philosophical thought process and talk about what it actually looks like in practice. What typically happens is we'll get a phone call either from an attorney or a survivor. If it's the survivor calling, I will be pretty brief and just say, try to avoid saying much except I really need to speak to your attorney. I'll explain what expert witness testimony usually is, what kinds of things it's possible to do with it and not possible to do with it, and explain that I really have to be able to speak with the attorney before anything else happens. I want to avoid hearing her story. I want to avoid in any way beginning to engage with her as an advocate, a listener, a counselor, a friend. So I try and keep it very, very businesslike, and give her the information so that she can have her attorney call. And then often that to me is the next piece. I'm not willing to go and call an attorney. If the attorney has the motivation and is really interested in talking through the possibility of having an expert, then they'll get a hold of us. And if not, to me that is already a red flag that that's probably not going to be a good working partnership. So the attorney needs to call us. If the attorney does initially or makes that follow-up call, I do want to hear what they want an expert for, and that's one of my key questions is what is it that why are you calling? What do you want my testimony to do? What's the purpose of it? And have them talk through that. What do you want me to accomplish on the stand that you can't get in another way? Why do you need me? Have them explain that. I tell them what kinds of things I want to review. I do want to see case information beforehand for a couple of reasons. One of the big ones is I want to know if this is even a domestic abuse case. There have been times when I've asked to review materials and I've looked at it and it really wasn't a domestic abuse case. It really was a sexual abuse case, and having somebody who is an expert in that field come in and talk would have been far more powerful. Or it was really a child abuse case with some poor parenting layered on top of that wasn't really domestic abuse. So I want to, if I'm going to be coming in and talking about an expert, I want to be relevant to the case. And I just don't necessarily trust somebody else to make that decision on my behalf, much less an attorney who is trying to advocate strenuously for their client and might be overreaching. And also I want to review materials because sometimes I see things in there that the attorney does not see because they are not the expert. And I can make connections and say, hey, did you notice this happened? Did you notice this? Or to me, I can clearly see why your client engaged in this behavior and help to explain that to the attorney. So I'll let them know what I need, and what I need is all kinds of case materials. I'll talk about that in just a second. I'm going to, in the process of that, I begin to get a feel for what that relationship would be like with that attorney. Are they open-minded? Are they looking for consultation as well as testifying? And honestly, I think that consultation and review and ability to give them an insight in a case is just as important, if not even more important, than what happens at trial. I will, at that point, once we've ended the conversation, assuming we're going to go ahead, I will usually send some kind of a written agreement, which is typically an email saying, okay, here's what we talked about, here's what I asked for, here's what I'm sending you, here's what I expect in terms of compensation, and just highlight all of that information and send it on to them. Typically also with my CV and sample questions to give them an idea of what kind of things I have or would testify about and what kinds of things are off limits. As far as some of the yes and no, when to do it and when to not, I would also add to some of the things that Lori said. I had an attorney call last week who is a prosecutor that has used actually I think specifically used Lori before, as well as other advocates in criminal cases. In this particular case, she was calling as someone representing a survivor in a custody case. And she said, hey, I need somebody to come in here and get on the stand and do a real quick power and control wheel 101 in this custody case. It's really easy. It'll take 20 minutes. You've got to have some kind of like prepackaged presentation. You're in, you're out, boom. That's all I need. And that was great that that was all she needed, but that was not all that I needed. And when I said I would like to have time to prepare, and when is this? Well, it was tomorrow. Well, tomorrow is not good enough. To me, that's an automatic no. Whether I was available or not, that's an automatic no. I would say within the hour, I had somebody call from one of our domestic abuse programs and saying, hey, this attorney called me and they want us to do this, and I have no doubt that we could, we were capable of presenting that information in a professional way, but should we? And she was seeing it as we are trying to work with that county. We're trying to get inroads and create positive relationships in that county, and wouldn't this be a great way to establish ourselves as experts and to build relationships, personal, professional, working relationships with that courtroom system by being there and doing this. And so what do you think, Kirsten? And my response was, well, it is an opportunity, certainly, but it is just as much of an opportunity to destroy your credibility. If you don't have anything to review and you walked in there and it wasn't really a domestic abuse case, if there wasn't any foundation for you to be testifying to begin with, if you are just taking this particular attorney's word for it, you will have just as much chance of making the judge and those other courtroom personnel think, well, they're biased, well, they're not credible, well, they'll do this for anybody. So it was an opportunity, certainly, but not necessarily an opportunity for what they wanted. So she decided after talking through that one day was not appropriate. And also I think one day, to me, is a red flag about how seriously that attorney takes my testimony. In other words, lack of preparation on the attorney's part does not warrant a crisis on my part to drop everything and make that testimony happen. I'm wanting to know, why didn't that attorney think about this beforehand? Why is that attorney suddenly making a last-ditch effort to suddenly throw more onto their case without really having it incorporated into their strategy? I will, having been asked, I have thought through and realized pretty quickly that I will not testify that there is not domestic abuse, which is an interesting thing to be asked. Please take a look at this and come back and say that my client is not a batterer. And it didn't take long to say I can't testify to a lack of something. So that's certainly a definite no. I think that some of the when to say yes and no depends on what kind of case, because I think we focused a lot on criminal cases, but there are all kinds of places for expert witness work. And you might say, you know what, we don't have the time and energy to spend preparing and working on a homicide case, but what could we do as far as providing expert witness help for immigrant battered women who are working on getting their VAWA petition approved? What can we do as far as child protection appeals or housing appeals where people have been evicted due to domestic abuse? There might be other kinds of cases where you think, that's something that we can do. Let's see. So we've had the attorney or the client call in. We've talked about the yes and no's and what we need and what we don't want and what we can do and what we can't. And in terms of what we need, I say, what can you show me? What can you show me that would substantiate domestic abuse? While you and I might think that there's a lot of emotional and threatening stuff that constitutes domestic abuse, our court system is looking for physical acts of violence. And so I want to know what do they have that's going to substantiate that. And it could be anything: police reports, healthcare reports. If there's filing for a protection order, I want to see what the person was filing, what they wrote. If there have been depositions beforehand, great. Diaries, text messages, emails, all kinds of stuff. I have a case sitting on my desk right now that is, again, about custody matters, and I heard a lot from the attorney about the domestic abuse, and the attorney sent me a very big packet that it took me more than a day to go through, but I found a lot of bad parenting and threats and scariness, but I honestly didn't find a whole lot of domestic abuse until like the second to the last page, where there was just one minor mention. There's just not a whole lot for me to go on. Now I've got about 30 hours of phone calls and therapy sessions that I can listen to see if there's anything else in that. But they sent me a lot, but there's still not a whole lot there. Faced with that, there have been times when I have emailed blank power and control wheel, and by blank I mean it just has like emotional abuse. It just has the topics, when there's space left that's blank underneath that, or body maps, and said, connect this person with an advocate and have them sit down and figure out a way for her to tell her story and talk about what has happened. And so with the blank power and control wheel, rather than looking what's already in there, essentially for her to be able to fill it in herself. That actually was a strategy I used as an advocate, helping women to prepare for their own testimony, was to talk their way around the power and control wheel. And that can also be a way that they can sit down with an advocate and generate something that I can look at that is essentially a report or an affidavit or a statement on that victim's behalf that would help to justify my involvement. Another thing is the danger assessment. Jacqueline Campbell and Company's danger assessment has also been useful as a tool to find a way for survivors to tell their story in a cohesive way, because it's often so nebulous for them. And I think
Kirsten, just please keep your voice up, okay?
Okay.
Thanks.
I'm going to speed it up just a little bit, because as I look forward, I think I could be redundant. So know that if I'm skipping things, it's probably because I've already said them or plan to later. So what are you looking for? You're looking for alleged domestic abuse. We haven't used that term a lot. It's important to get that comfortable in your vocabulary. You're not trying to decide truth, fact. That's the court's job. You're looking for alleged instance of domestic abuse within the material that you've read or the evidence you've been given. And then how does domestic violence fit into the story of the case? So she delivered drugs for him or translated for him in his drug dealing business. Does domestic abuse help explain her behavior, why she did that? Can you link that to the crime that she's charged with? If she didn't protect her kids in the way that people from the outside believe she should have, can you help explain why she might have been protecting them in the way that was effective because of domestic abuse? So things like that. Think about how your knowledge can help round out the story, and if that full picture of the story is necessary in her case. There may be more to the story. It just simply may not be necessary to provide it to the court. Again, look for what problems you can help explain. All the things that are difficult. Victims' use of force, use of drugs, dropping no contact orders, those kinds of things may be able to be explained by giving the court information about domestic violence. Figure out what the attorney's theme, trial strategy is, and will your testimony fit into that? Will it help better tell the story? And then can you resolve your own hoops and fences around those issues? And for us, that's jargon Kirsten and I use to describe our own personal biases and how that, if those get in the way, it affects how high women have to jump through our hoops or over our fences in order to get services. And without really examining those and doing so with trusted partners, your hoops and fences can be at play more often than you think. So you either need to figure out what they are and can you still remain unbiased in spite of them, or if you can't, you need to find someone else to do that piece of the work. A client contact, we've covered this a lot, but I thought I would just give you a brief strategy and how I handle it. Our first introduction to the case is often a victim calling, begging us that she's heard from another survivor, that we helped her in court, would we please help her? If I think she's asking for expert testimony, I stop her as early as possible and explain to her what my role is and why, if I'm going to testify as her expert, it would not be good for us to have further contact or for her to share details of the case. For me, that is not a difficult conversation for her to have, because I also make sure I give her good referral information about advocates, because I want her to have an advocate through this process. I also tell her that it's important that her attorney contact us, because she then wants us to make contact with her attorney, and we don't do that. The attorney does need to take the initiative to contact us. After agreeing, I show up the day of deposition or trial, and I usually do introduce myself. I walk up and I have a little spiel that I say. I tell her who I am, and that I know from past experience it can be really difficult to hear a stranger talk about your life on the stand, and that I'm sorry if that's hard for her, and I will try to do my best. And that's it. Then I walk away and I disclose that to the court if they ask if I've had contact with her. If I've had prior phone contact or inadvertent contact, I document that, and I always disclose it when asked so that I can remain transparent and don't lose any credibility. Attorneys will pressure you to have contact with their client, either because her case is compelling or she's compelling as a person. So they want you so much just to meet her. If you just meet her, then you'll understand and you'll want to help her. Or the opposite, she may be very difficult, very angry, and the attorney wants you to meet with her so you can fix her for the attorney. Both things happen frequently, and it's important to, in my perspective, stick to your guns. I do believe that the kind of work Kirsten and I do, it's important that we not have that contact in order to remain, at least have the perception of being unbiased to the court. They will always ask you if you've had contact with either of the parties, and if you've had an ongoing relationship or ongoing contact with the victim, you're starting at a disadvantage immediately. We do a lot more consulting anymore than we do actually show up to testify. We have a long list of attorneys that have used us over the years, and they often will list us in their trial information as going to testify, but only in an attempt to get a plea. And that frequently happens now, and we encourage that from attorneys we have worked with in the past. As a consultant, we are a sounding board sometimes for the attorney to help the attorney understand possible motives for behaviors of either party. If we're not going to testify, we may agree to help interview the victim still as part of the legal team and give insight and better questions for that interview. We might help develop a strategy or create the story for trial. We can talk about how to predict batterer behavior and strategies during the case. And then important, if you're not going to testify, that you also are ready to link the victim survivor to support services by providing good referrals. For us, especially in cases that have a bad outcome, we want to make sure we're connected with her because we do provide services to incarcerated women, and we don't want her to feel like we've simply failed her and abandoned her. We want to follow up with support services. We do quite a bit of consultation around jury selection, and again, that's just talking through what we've experienced jury behavior and outcomes to be, and are a resource in that way. Okay, Kristen's going to take over.
And I'll try and speak up again. I'm going to be brief because I think both of us have been pretty thorough on a lot of this stuff. Should you testify? There's been times when actually I really wished that I could, and I decided that I was not the best messenger, that they really needed somebody who was an expert in some other field. For example, you really just need somebody to come in and with a formal post-traumatic stress disorder diagnosis. That's what you need. You don't need me. I'm not going to be as useful. So that's important too, is I guess check your own ego about your necessity to a case. And there have been times when I started out as that consultant, and one of them in particular comes to mind where it was the survivor that called. She said she was struggling with her own attorney, having the attorney understand. So by the time that I had been a consultant, which really meant advocating on her behalf with her attorney over the course of several months before we even got to the hearing, it was clear that my role had flipped and I was no longer an expert witness or a consultant. I was clearly simply being her advocate. And at that point, then the expert role was switched over to Lori, which was nice to have somebody who was already conversant in what was happening to step into that role that I needed to step out. So you have to watch your hat from the beginning, and you actually have to watch your hat through the whole process. Working with an attorney, I think, again, we've covered a lot of this already. What exactly are the attorney's strategies? That's very useful. If they can give me questions that they want to use ahead of time, it's helpful for them to know what I'm going to say. So sometimes having a chance to sit down and review before the testimony and make sure that there isn't any place that I'm going to go that they don't want me to go. There may have been things that were already decided beforehand. For example, history of substance abuse that the attorney wants to make sure that I just steer completely clear of, and I don't inadvertently bring that up as an example that might open the door to something that they don't want brought into the case. So having a very clear idea on both sides about what that testimony would look like, sending samples, that's great. And certainly if I have particular concerns or worries, to feel free that that attorney is going to take those seriously and talk with me about them. I think that we've covered a lot of this, so I'm going to just pass it back.
What you will not testify about, and these are important to think through because these are often the things that the attorneys have a very vested interest in pressuring you to do. Diagnosing either party, unless you have a degree that allows you to do that clinical work, do not do it. And that even means saying, yes, indeed, based on what you've told me, she's battered or he's a batterer. Really work to not say that kind of thing. Don't testify in areas beyond your expertise, and that's beyond what the court will accept as your expertise. So, for example, I work for the Domestic Violence Coalition, but I worked for 10 years in a rape crisis center. I believe I'm an expert on trauma. That doesn't mean that I'm the right expert to go in and talk about the trauma of sexual assault. There are better people to do that the court will accept their credentials better. Don't testify about specific predictions around future behavior of either party. Based on his past behavior, I'm pretty sure he'll batter his next partner. You can't say that. And what's complicated but important to note is you can't testify about batterer characteristics in prosecution cases because they will decide that that's profiling, and you can't do that if he's the defendant, to the defendant. So in tort cases specifically, I want to caution you that the attorney will try very, very hard to get you to give a specific opinion about, yes, this survivor was indeed battered, and the defendant is definitely a batterer. It's their bread and butter. It's how they're going to get money in the tort. So I always say ahead of time to attorneys, especially in tort cases, if you ask me this question, you will not be happy with my response on the stand. Please do not ask me this question. And even having said that, and I say it multiple times, they will still ask you that question on the stand. So make sure you're ready with your answer as to why you can't and you're not qualified to make that determination. Next steps. Really helpful to watch a trial. Watch an expert, someone that you think is good at what they do. Watch several if possible. Start developing your curriculum vitae now and keep it up to date. I would tell you, Kirsten and I both have found that that's by far the most challenging thing. And keep track of the cases, their resolution, the vital information about who the victim was, who the attorney was, who the defendant was, because at some point, especially in federal cases, you'll be asked to give a list of those and their outcomes. And that was something that was pretty challenging to recreate years later. So try to keep up with that. Find a mentor that who has testified as an expert that can help. And then do mock trial practice. If you have an opportunity to do a training that does mock trial, very, very helpful. We did one a couple of years ago, and we hand-selected advocates in our state that we thought would be very good at this. Long-time, seasoned advocates that we believed had good knowledge base and presented well. And what we learned through the mock trial practice is that you really don't have any idea who will be good at this until they do it. We had directors who we believed would be great resources who simply froze on the stand, who got hostile under direct examination. And so it doesn't necessarily bring out the best skills in people. So make sure you've practiced and you've watched people that you'd like to emulate. And then, as Kristen said, write out your hypothetical testimony. I do that because I want to be in a groove when I testify. I want to make sure I cover everything that I think is important. And in that way, the attorney can also develop their questions for me based on what I'd like to talk about and in the order that best helps me in preparing. And then, lastly, you've heard us say this a few times, but read, read, read. There's nothing more embarrassing than when someone poses jargon to you on the stand that they assume you should know because you're in the field and you've never heard it before. Now, I would also tell you that's a strategy by opposing counsel to come up with some obscure jargon or research study that no one in our field knows about because it was benign or silly, and make you look silly because you don't know about it. And if you've done a good job with the rest of your testimony, the answer to that is that's not a study that I'm aware of, period. And usually the question hopes that you'll actually say you are aware of it, and it may not exist or it's just bad research. Kristen already said be versed in controversial research. Anybody that's actually written about the work that we do in a way that will show up on the other side, important. And then look at best practices in the field, protocols. If you've developed protocols, that's very helpful for the court. Best reading lists, go to the National Resource Centers. Any of them in the country will have good resources, especially in topic areas. And start areas that interest you, but you've got to read a lot. There's things about false memory syndrome and parent alienation syndrome that will come up in your trials, especially in civil cases with child custody. And you're going to want to know how to handle those and have your testimony ready. So I think we're ready for questions.
Well, we're almost at the end of this webinar, and we have had a number of questions. So what I think we're going to need to do is two things. One is consider a part 2, which I hope you guys will consider, because some of the questions we're getting into specifics of what to do in certain circumstances. And then the other is we can also send out some information in a follow-up email to folks who are on the webinar now. Because one of the specific questions was about whether or not you were willing to share your procedures that you use for screening. Is that something you would share, or do you feel like it's something that people need to create themselves, or could you at least provide some guidance for people?
Oh, definitely.
Okay.
Sure. We can, as long as people understand that they're relevant to our resources and our time and knowledge base, we can definitely do that.
And then another question that came up was about the reading list and whether or not that was something that you had prepared that we could share with folks.
Yes,
okay.
We can share our reading list.
Okay. And the other thing I will say, this is SUA stuff. The other thing that I would say is that we have actually been talking, Cindine from our office has actually been talking to a number of experts and asking them this question. And it's been very interesting because a lot of them create special reading lists specific to the case they're working on. And Lori pointed out that some of the controversial or special topic areas that may come up in a case are things that you also need to be apprised of. But we can email that out in the interest of time, and that will take us a little doing to put that stuff together as well. Just in the interest of time, I just am wondering, Lori and Kirsten, if you have any final words that you want to share. And I do apologize to folks that we were not able to get to all the questions. But Lori, Kirsten, Cindine, and I will take a look at the questions and figure out if there's some of them we can answer via email. And if we cannot answer them via email, then we really do want to consider a part 2, if that's okay with you, Lori and Kirsten.
We would be happy to do a part 2. And okay. I apologize for taking up all the time. I was talking really fast. I thought I was leaving lots of time until I looked at my watch.
It's not
I'm happy to do a part 2, happy to work on some specific information in an email. And the coalition is swamped right now, but I will also entertain individual emails if it's something, a piece of information that we can help with just on an individual basis too. So.
Thank you so very much. It was just an incredibly informative and thought-provoking webinar, and it, as I said, you guys really are out there helping all of us, I think, really ask the hard questions that are just absolutely necessary to consider before going forward. So I really appreciate you pushing us to really be thoughtful about the work that we're doing. And Carrie, anything before we sign off?
I don't think so. Just a reminder that we will send out an email shortly with a confirmation of your attendance, and we'll also have a link to a little survey that we'd appreciate any feedback for. That's mainly it, and just thank you all for joining us, and thank you so much.
And Lori and Kirsten, oh, I'm sorry, Carrie. Lori and Kirsten,
nope,
any final words? You don't have to.
No, I'm sorry, we've muted.
Come on back. Any final words before we?
Nope, we've used all our words.
Okay. All right. Thank you so much, everyone. And we are all going to hang up, and it will, turn this thing off. And as Carrie said, we plan to post a recording of this webinar that will also have the PowerPoint along with it on the National Clearinghouse for the Defense of Battered Women website in hopefully 7 to 10 days or even sooner. So just go to our resources tab, and then you'll be able to get a copy of the webinar. And like I said, we're also doing the best we can to get our announcements up there as well. So hope to talk to you soon. Thank you for your participation, and thank you, Iowa. Bye.
Thanks, everyone. Bye-bye.